Hello, everyone, and welcome to Week 5, Chapter 3 of our course in Employment Dispute Mediation. This week, we're going to get more deeply into the role of the mediator. You might recall in the first week, we talked about a number of questions in introducing mediation, a number of questions having to do with the mediator's role and function. I put this slide up just so that you could reflect upon those questions. And I want you to know that as we get into this week's material, we'll fill in more of the information regarding issues in answering those questions. When we talk about role definition for a mediator, we can look at it kind of as a mission statement. Role conception, or how a mediator conceives their role, is very important, both in terms of outcome and the amount of influence that will be exerted in the process. And as I said before, there's a great debate existing in the mediation field about the role conception of a mediator. What should the goals of the mediator be? How much influence should the mediator have both on the process and on outcomes? And regardless of what orientation the mediator may have in that regard, whatever the mediator perceives as their role in terms of their conceiving their goals and their approach to mediation, it's going to have a significant impact on both the outcome and the process and the outcomes. So when we look at role conception, we are looking at basically two things. What kind of outcome should this process produce, and how much influence should the mediator have and exert in that process? Well, historically, most of the time when we think of mediation and we think of goals, the goals that have been thought of most often are the goal of solving the problem, resolving the dispute, settling the case. And the justification for that is that that's what the parties expect. Many times when people go to mediation, they're not going there for therapy. They're not going there to see how they can personally be enriched in terms of their own skills and their own ability to reflect and so forth. They're going there because they got a problem, they've got a dispute, and they want it resolved. And they're led to believe that by going to mediation, there's a greater chance or opportunity for them to resolve that dispute, conclude the transaction, settle the lawsuit, or at the very least, narrow the issues in the controversy. And so that becomes a focus both of participants and of lawyers and other folks that participate in mediation. And of course, there is some societal benefit from assisting parties in averting continuing conflict, whether litigation, stalemate, or even violence. So when we think of a mediator in terms of their role, how they conceive their role, it becomes very important, but there is a lot of pressure, so to speak, for those goals to be to surround the objective of solving the problem or settling the case. We're going to see today in the various orientations that mediators have in terms of how they can how they perceive their role to be, or their role conception, that there is vast differences in terms of what that should look like and how much influence mediators should have. Now, if we look at this conception of what kind of outcome should we have and how much influence should the mediator have, we can look at it through two lenses, at first two lenses, and then we're going to expand this. One is narrow settlers. People that are narrow settlers are most frequently focused on the positions or pleadings of the parties. They're looking at solving the dispute, and they're usually doing that by competitive or distributive bargaining terms. The mediators who are narrow settlers often have a discussion if they get into outcomes and making suggestions, focus on litigation cost and risk of as a primary tool to get people to settle. So they'll look at parties and their positions, and they'll hear their support and their arguments for and against positions taken by the various parties. And then the mediators, as they get involved in trying to get people to settle, will try to point out the weaknesses or the vulnerabilities that people have in their presentations, whether it be the arguments that they have, the evidence, the projection in terms of trying to estimate or guess as to what would happen if the matter were to go to trial. Now, they may acknowledge the benefits of a broader interest-based approach in looking at the interest of parties, but folks that are narrow settlers in terms of their mediation orientation usually find that those approaches are just too time-consuming, or perhaps they require skills they lack. So again, the outcomes tend to be reached through competitive bargaining. You often see the narrow settlers associated with court mediation programs. And court mediation programs kind of lend themselves to narrow settlers because there is a narrow focus. A case has been settled, there's litigation pending, a court has sent the matter out for mediation, and there's limited time, limited opportunity. And again, because the court has sent this matter out to be mediated, the focus is on getting it off the docket. And so there's a lot of pressure, both on the parties and the mediator, to try to get the case settled. So it's closely related to the push for speedier, less costly alternatives to litigation. Narrow settlers look more to the past than to the future. Now, if we look at broad problem solvers, well, they're also motivated to end or resolve the dispute. But again, this approach, this orientation of a mediator, goes beneath the parties' stated positions to identify their real concerns or interests. Why have they taken the position they have taken? You remember the orange. Why do you want the orange? So again, when you look at this from a problem-solving approach, this broader approach, you're necessarily going to be involved in a process that takes more time, it takes more effort, it's more difficult, but you're going to look at perhaps legal and non-legal concerns. When you look at legal and non-legal concerns, then you're getting to the party's interest, and any resolution that you reach has the potential to be more satisfying, more enduring, more lasting, more helpful to relationships than are the narrow settlers. So again, because we're looking at something broader than just legal positions or very narrow outcomes, we also tend to be more focused on the future in broad problem solving mediations. So rather than looking back at the past as to what happened in the past and who's at fault, who's right, who's wrong, we're looking to the future. And so there are relational solutions that focus on really the actual or potential future dealings of the parties. If we're looking at an employment situation and an employee makes a claim for discrimination or for harassment, and let's suppose that we're dealing with an employee that has been with the company for many years, is a valuable employee, and things have gone off the tracks, and it ends up in litigation, communication is broken down, there are emotions that are very heated, and when we get into mediation, if you're a narrow settler, then the focus of the mediator and the parties is going to be on the rights, perhaps on the power, they're going to look to the past to dissect what happened and who was right and who was wrong. And most often, the kind of outcome that is going to evolve from that process is going to be one that is perhaps a zero-sum fixed pie kind of thing, a payment of damages, an estimation of, well, if you went to trial, you might get this, you might get that, you might lose, you might win. And so you tend to have that focus in the narrow sense. Now, if you take those same facts and go into a broad problem-solving kind of mediation, perhaps you're looking at why the person felt like they had been harassed or discriminated against. You might look at what is really at play here. This employee, let's suppose that it's an individual. Let me take the first example, an individual maybe in his 60s, has been there a long time, actually knew the owner of the company when it was started, was there along its growth, provided great service. But then as time went on and technology got ahead of where this particular individual was, maybe the original owner, creator, founder of the business has passed away, a younger son has come in, and so the fit of this employee isn't quite the same as it used to be. And so maybe there are reasons why there's an effort to change the position of this person, or maybe even lay them off or have them no longer involved with the business. When we're looking at that kind of a situation, if we were looking at it in a broad problem-solving thing, we were looking at interest, perhaps this employee's interest, his identity is tied into his work, his job. Perhaps he's close to retirement, has saved a lot of money. Money's not really the focus, but his identity, his dignity, his position, his reputation. And so if people were looking at solutions, maybe they were create a position or a title for this individual that would recognize the contribution that he's made to the company over the years. And while reducing his involvement in the company, protects his image in the company. Perhaps it's the location of his office, perhaps it's hours, perhaps it's a number of other things that would not come into play if you were looking at it simply from a very narrow, settling focus. So broad problem solvers expand or extend the breadth of the problem to be solved. Look at legal and non-legal issues. Look at interest. Look at emotions. They look at things that might be driving the dispute. And the beauty of looking at this is that you can often find solutions where economically it's not as expensive to resolve the dispute. In fact, it may not only be less expensive, but it also might help the business and the relationships and the whole attitude of a company, where there's this focus on the human side of conflict, the emotions, the feelings, the impact that it has on everyone else. So broad problem solvers, narrow settlers, those are two views or two orientations. And there is a third. In terms of mediation, there is the transformative objective. And this is interesting because transformative mediation, the transformative mediation founders wanted to look at conflict primarily as a crisis in human interaction. Their focus is not on trying to resolve the dispute. That is secondary. What they're focused on is the people that are involved in the conflict and their ability to communicate and interact in a healthy way. Now, this is the antithesis of being directive. This is a hands-off approach in terms of the mediator's influence over the outcomes, the influence over the process. Really, the mediator's job is to help reverse this negative spiral of conflict and reestablish a constructive interaction between the parties. What do I mean by that? There are two aspects of transformative mediation. And if we can think of it in terms of these two components, it'll be easier to visualize. Empowerment and recognition. Now, first of all, transformative mediators believe that people that are in these conflicts have experienced a breakdown in their own self-value, in confidence in their own capacity to handle life's problems. They believe that this breakdown in their psychological ability to deal with whatever's before them has been impacted. And so the transformative mediator wants to reestablish or provide this empowerment where people believe that they can and do have the capacity to handle their own problems and resolve their own problems. So part of it is looking internally to this empowerment. The other part is what we call recognition, and that's looking externally. It's trying to get people, each participant, to acknowledge that there are other perspectives to a particular dispute. There are other ways of looking at the dispute, and that really necessarily involves having empathy for the situation and the problems of others. You know, there's a metaphor of an elephant, and I can't remember the exact name of it, but if you can just picture a big elephant and picture a number of blind individuals that are surrounding this elephant, and they're reaching out and they're touching the elephant, and they're describing what an elephant is. Now, the person that's closest to the trunk is reaching out and touching the trunk and giving that description is going to have a much different perspective of what an elephant is than the poor guy at the back who, while the tail is swiping him in the face, is reaching in to this reaching over to this various area and describing an elephant from the posterior position of the animal. Now, they're both right and they're kind of both wrong, aren't they? But they're seeing things from their perspective. And a transformative mediator is trying to get people to recognize that there are other ways to look at problems and situations. And so with this empowerment and with this recognition, the idea is to transform the individuals in their ability to have a greater quality of conflict interaction. They both, and this is the quote, reclaim both their sense of strength and competency and agency and their understanding, responsiveness, and connection to each other. Now again, settlement's not the goal of transformative mediation, but it is seen as a likely byproduct of the process. Okay, so we have looked at these areas: narrow settlers, broad problem-solving settlers, and also the transformative mediation orientation. So now we go from goals to action. How much influence should the mediator exert? And when we get into this discussion, we're going to get into it by looking at three ways in which a mediator has the potential to exert influence on the parties and the process. First of all, let's look at the structure and ground rules of the mediation. That usually happens, before the parties actually meet. It might have something to do with, who the party's going to be that are going to be there. Where is it going to take place? Who's going to participate? What kind of, when I talk about ground rules, I'm talking about, are we going to meet, are the parties going to meet together? Are they going to start out in a joint session? Are they going to start out separated? Who's going to talk first? The date, place, and things of that nature. Okay, so it's kind of the initial phase of the mediation. How much influence? And mediators generally have a lot of influence over those issues, and they're often not contested, except for you might have an argument about whose office the mediation, where the place in the mediation, is it going to be in one party's office or the other, or a neutral third place. But generally speaking, a mediator could have significant influence over the structure and ground rules, regardless of whether or not they're on a facilitative orientation to mediation or a directive orientation to mediation. Okay, then we talk about influence over the process in operation. You know, the mediation has been started, so we're in the mediation, and now someone's going to make decisions about who's going to talk. Now, again, some of those decisions may be made before in structuring it. You may plan the mediation so that a party's going to start out separated or start out together. But some of these same decisions might occur in the process itself. For example, the parties might start out in a joint session, and then emotions are heated, people are arguing, it's becoming dysfunctional. And so right in this process, decisions are made about the process. In other words, okay, we're in joint session, now we're going to separate. There are decisions in the process, again, that have a relationship to the ground rules. Are we going to allow interruptions? Are we going to let, so-and-so have, uninterrupted time to talk, and then you're going to have 10 minutes, and this person's going to have 10 minutes? The process might involve the agenda. Perhaps when we talk about multiple issues, what issues are we going to talk about first? What is the priority of these issues? How are proposals going to be presented? How are possible solutions going to be created? So there is that influence over the process. Again, mediators tend to exert quite a bit of influence over the process. And a lot of times the parties, the attorneys or individual participants, will actually ask the mediator, what is your, how do you do this? How do you do that? And do you want us to submit a brief before? Do you want us to include certain information or documents and so forth? So there might be some deferring to the mediator in terms of process. Now, again, you might get people that are so committed to this facilitative orientation that even in process they want the parties to make decisions. But that isn't where the real the debate isn't strongest in the domain of process. The debate is strongest in the influence over the outcome. What kind of outcome? How is the outcome going to be derived? What is the negotiation going to look like? And is the mediator going to simply be a courier of proposals and counter proposals? Or is the mediator going to actually get involved in talking to the parties about, and let's look at a continuum. A mediator might just simply carry proposals back and forth and not say anything, not give a recommendation, not give any advice, any coaching or anything. Maybe the mediator isn't going to coach or give advice about the substance of the proposals, but maybe the mediator's going to offer suggestions about how the proposal should be packaged or how it should be communicated. If we're talking about concessions, maybe the mediator will make suggestions about the timing and amount of concessions to both parties. But those are all questions that come into play over the debate about how much influence the mediator should have in both the structure, ground rules, the process, and the outcomes. Now, a lot of mediators and mediator theorists or people that write and study about mediation or make recommendations about what the best methodology is, they might make a statement, or let's say that they have, that it's best to separate process from outcomes. It's okay for the mediator to have a lot of influence over the process, but when it comes to outcome, the mediator should stay out of it. And I really like the statement in our text where it said there are 3 reasons why this is easier said than done. First, the mediation is a dynamic and fluid process. And so you're going to be making decisions both before, during, and perhaps even after the mediation in terms of process, ground rules, and outcomes that all tend to be dynamic and intertwined. The mediators and participants' views about how to define the problem are not static, and they can continue. Start out thinking this is the issue, but then it blossoms into a number of other issues, number of other aspects. And then again, as the mediator's making decisions about are we going to be in a joint session? Are we going to be in totally in caucus and separate meetings with the mediator? Now think for a moment what the difference might be if you're in a joint session or totally in separate sessions with the mediator. If one of the potential outcomes of the mediation is to help repair a relationship where emotions are high, if a decision's been made to meet solely apart in caucus where the parties never interact, then the potential for any kind of repair of the relationship is probably greatly jeopardized or the opportunities diminished by virtue of that. Now, there may be great reasons for having the parties separated. On the other hand, if the parties are together and a mediator forces the parties to be together and emotions erupt and people get very angry, you might lose the opportunity to have a resolution of the dispute when the parties get up and walk out. And so by forcing the parties to meet together, if that's what the mediator has done, the mediator may have had a tremendous impact on the outcome being the non-resolution of the dispute by virtue of the decision made on process. So this is it's very difficult to separate process from outcome totally. You probably have less debate over a mediator's influence over process than outcome, but it's important to keep in mind that they are necessarily intertwined. Now, this slide looks awful, and you can't read it. I can see here that parts of it are cut off. But let me just give you, most of this comes from our text, and it gives you kind of a glance at the differences in a mediator orientation from a facilitation orientation to an evaluative orientation. Now again, if you're on the left side and you're talking about facilitation, the process of communication in the facilitation is aimed at generating a negotiated agreement of the party's own creation. In other words, you're facilitating the party's communication. You're not trying to impose, as a mediator, your view of the conflict or your view or vision of what's fair and appropriate. So you're not providing, as a mediator, your own opinions or ideas for solutions, at least initially. You're not doing it. You're trying to facilitate that coming from other parties. You assume that the parties know their situation better than anyone else, and so they are best situated to come up with their own proposals, their own ideas for solutions. The focus is probably more on the process. You're trying to, as a mediator, create optimal conditions for each of the parties to be able to communicate and resolve their problem. Let me give you an example of that. If parties are in a joint session and they're angry, they're just totally kind of being irrational because that anger has caused their emotions to cloud their ability to think rationally, and the longer it goes. Now, mediator, again, is trying to create an optimal condition for people to be able to resolve their own problems. So even a facilitative mediator may make a decision that it will assist the parties better to separate them, let them cool down, let them be able to regain their composure. Maybe they'll get back together, but maybe they won't. Maybe it's better to communicate without being face to face. Again, a mediator might look at proposals and reframe or repackage how they're communicated so that they're less offensive, less judgmental. Their mediator is going to model good communication. The mediator is going to try to create an atmosphere of trust and rapport with the parties. And again, I'll go back to those 5 core concerns. A mediator that can use the core concerns as a lens and a lever can assist the parties in having the best potential for resolving a conflict with their own ideas, with their own solutions, if the mediator can create that environment for the parties to have a healthy process or an effective and appropriate process. Now, again, the mediator can do this by asking questions. And again, the way a mediator asks questions, the way a mediator frames questions, it can be very, very important. And we're going to talk about that in a lot more detail as we go through this course. But even the sequence of discussions and whether or not it should be shared with both parties, one of the parties, again, the mediator can be a reality check to parties as well. And we're going to talk about how you approach that. You know, I've often said there are differing ways to deliver a message. One of the simplest, probably the simplest and maybe crass definitions or descriptions of diplomacy that I ever heard was the statement that diplomacy is the ability to tell someone to go to hell in such a way that they look forward to the trip. And again, a mediator has got to be able to reframe, structure, communicate, model all of these things in such a way that it's a more effective and a more productive environment for the parties. Now, again, in purely facilitative mediation, and a purely facilitative mode of mediation, the mediator is going to try to avoid any pressure of any kind as a method of achieving resolution. Now, if you flip to the other side, the evaluative mediator, and again, you can see all of these on a continuum. Some are more extreme than others. But in evaluative mediation, there's an assumption that the parties want the mediator to assist in reaching an agreement. They want feedback. In fact, and this is not just an assumption, but it's true very often, depending upon the type and context of the dispute. Many times mediators are hired, they're retained because of their expertise, because in their neutral and unbiased state, they have experience and they have knowledge and education and backgrounds that are valued by the participants. And since they couldn't negotiate a resolution on their own, they want a mediator to provide that feedback that they can then rely upon. This often happens, and I may have mentioned this in my last lecture, where let's say an attorney is trying to convince his client to accept a settlement that is in the client's best interest. But the more the attorney tries to convince the client to accept this settlement, the more the client believes that the attorney is just wimping out and giving in and selling out the client. And so the attorney may be looking to a mediator, some other authority, some other person or persons, if it's more than one mediator, that can then provide cover, so to speak, and help convince the client as to what's in their best interest. And so those become important. Now, there may be very important decisions made about when that feedback is provided. When is that evaluation? Even facilitative mediators sometimes might use evaluative methods, but use them differently or maybe as a last resort. I'll talk about that in a minute as well. Also, the mediator might be looked at for feedback because of their industry knowledge. You know, perhaps this is some kind of a harassment case or discrimination case, and the parties have selected this very well-respected retired judge to be the mediator. And both parties want the mediator to evaluate the case and give them an opinion that they can then evaluate, rely upon, and use to give advice to their clients as to what posture they should take in resolving a case. Now, the evaluation might be based on law, or it might be based on other specialized knowledge. You know, you might have a mediator who's a construction expert, an architect, and we're talking about design defect. We might have someone that has been in human resources and or general counsel, and maybe they have a lot of experience in dealing with various disputes that often arise in employment situations. And so the parties are looking for that specialized knowledge in order to give their perspective about on the dispute and about what they would recommend. With respect to legal evaluations, mediators may be called upon to evaluate the relative strengths of the party's position. As I said before in our previous lecture, when it comes to litigation, there is no sure thing. Many people are overconfident that they're right, the law's in their favor, the facts are in their favor, God's in their favor, and so it's just an absolute certainty in their mind that justice will prevail and they will win if they go to court, and no matter how far they have to go in the process. But often having a more realistic idea involves a mediator with this specialized knowledge predicting a court outcome and not necessarily saying you're going to win or lose. Now, I can tell you that for many, many years, when I had clients or other people as a mediator, I had people say, what do you think the potential outcome? I would start with the premise that there's no way to predict what the outcome is going to be with certainty. The best you can be is an odds maker. And I like to use the example of the television show, Let's Make a Deal. Now, I'm old enough to remember the original, But whether it's the original or the current one, we all know the premise of the show. Participants are asked to come down. The host is holding the microphone and is looking to three large, like kind of garage doors. Door number 1, door number 2, door number 3. And behind one of those doors is just the most magnificent prize you can imagine. Maybe it's a new car, maybe it's an airplane, maybe it's, just absolutely everything you would want. In litigation, I would liken that to the verdict you think you're going to get and deserve. It's the best case scenario for your litigation. It's a total win. Then you have door number 2. Door number 2's, it's okay. Maybe it's a suite of patio furniture and a new grill. Maybe it's a vacation, or something. I mean, it's good. It's better than losing, but it's not the the big prize. Now, door number 3 is a whole different situation. And if you've seen this show, you've seen the old donkey. There it is, just a plain old donkey. Or even worse, maybe it's worse, it's a pyramid of Alpo dog food. That's the loss. That's the disappointment. Now, in litigation, I often tell people, going to court is like, let's make a deal. Now, you're here at a mediation. You're trying to make a decision as to whether or not I should go to court and pick door number 1, 2, or 3, any of which, the odds are. And maybe the odds of your case are so good that more doors are going to have the good prize than the bad prize. But, gee, I tell you, there are very few cases that don't have at least one door with the borough, in it. So there the host is with a stack of bills. And that host is saying, you can either go to trial and have door number 1, 2, or 3, or you can take what's in my hand. Now, the person's going to decide, am I going to settle or not? So it's like the person looking at me, the mediator, and saying, should I take the host money, or should I choose door number 1, 2, or 3? And my response is that I can only be an odds maker. It depends on how much money's in the hand. Now, if there's only $1 in the hand, well, that's easy. Go choose door number 1, 2, or 3. Now, if you think your case is worth $100,000, and they give you $5, $10, of course, you're going to choose door number 1, 2, or 3. Let's suppose that in the hand of the host is $50,000. Are you going to take $50,000? That's half of what you think your case is worth. Or are you going to gamble on one of the doors? And the more money, or the more whatever, if it's not money, the more of what you want, whatever it might be, monetary or otherwise, is in the hand of the host of that show, the greater pressure there will be on someone to accept a resolution. Now let's look at this from the perspective of the mediator. A purely facilitative mediator who is not giving opinions is going to keep their mouth shut. They're going to say, hey, that's up, you have to make that decision. Well, ultimately, they do have to make that decision regardless of what the mediator says. So a purely facilitative mediator is going to offer no opinion on that. They're just going to say, those are your choices. And the mediator, the mediator's representative, or the party or the party's representative are going to have to decide what they do, what they take. Then if you have on the other end of the spectrum a very evaluative mediator, very directive and aggressive mediator, that mediator may sit down or stand up with the party and say, I believe you should take what the host has in their hand because I think, it's my opinion based on my experience, my evaluation of the arguments, the evidence, everything that's been talked about here today, that if you go to trial, you will not do better. The chances are you will not do better than what is in the hand of the host. Now, again, there's everything in between on that continuum. What may happen is that the mediator initially doesn't give an opinion, allows the parties to communicate and work it out. And if the party reaches their own decision, fine. But if they get stuck, if they reach an impasse, then the mediator might continue to provide more feedback and more information in order to try to break that impasse, and do it on a continuum basis. And we'll, again, talk about that in more detail as we go along through this course. The evaluative mediator is more of shuttle diplomacy. They're just going to take, they're going to go back and forth and say, okay, here's this offer, what's yours? Take that back and forth. But in highly directive forms of evaluation, the mediator is not only going to deliver these back and forth, but is going to put a lot of pressure on the parties. Many times, often and unfortunately, the most pressure is put on the weakest link if the major goal is to get the matter resolved. Now, again, if we were to look at the context where you find these evaluative mediators most often, well, necessarily you're going to find it very often in court-based or private commercial mediation settings where efficiency is valued. Court has a very large docket of cases, is trying to thin out the cases, and so the matters are sent out for mediation. And the expectation of the judge who's sending them out is get them resolved. And the focus is more on the resolution than it is on any other particular goal. Now, this is another way to look at both the evaluative and facilitative models in connection with the narrow and broad. So you can see that people can both be narrow and evaluative as mediators. And you can see what that would look like up in the upper left-hand corner. You can see people that are very broad and very facilitative in the lower right-hand corner. Then you might have people that are both narrow and facilitative, or both broad and directive. And I think this is a pretty helpful visual to kind of look and see what those characteristics would look like in a mediator that adopted any one of those particular orientations. Now let's talk about fundamental norms associated with mediation. When we talk about these fundamental norms associated with mediation, they're kind of themes or values that are meant to be inherent in any mediation. First, party self-determination. The idea behind mediation is that the parties are in control. No one can force them into a resolution or a settlement. No one imposes a decision. It's not a trial. It's not an arbitration. The mediator is not there to force anyone to do anything. So in party self-determination, people are supposed to be empowered to make their own decisions. Then you have mediator impartiality and neutrality. The mediator is not supposed to have an interest in this. They're not supposed to be biased. They're not supposed to care one way or the other what the outcome is to be. And again, they're supposed to be neutral and not taking the position of either side. Now, if you look at those just as stated, they may seem fine, but in actually putting them into practice, they become a little more difficult. For example, a mediator is supposed to be neutral. But then they're also parties are supposed to have self-determination, which would mean that they are empowered to make informed decisions about whether or not to resolve dispute and on what terms. But what if the parties have a very unequal advantage, both in power and knowledge? Let's suppose that you're mediating a claim, and here's this poor individual that's been in the country for a short period of time. They don't have a lawyer. They may struggle with the language. They don't know the laws. Perhaps they've been employed, and by this employment, I mean employed legally. And let's suppose that they're employed by this company, this individual, who's quite well to do, quite well educated, has a lot of knowledge, comes to the mediation with a lawyer. This poor immigrant has neither a lawyer nor very much knowledge about the system. And so during the mediation, the employer is intimidating, is threatening. And you know that what the person is being told is really not true. If they don't settle, they're going to be deported, or they're not entitled to any kind of payment for overtime hours, or maybe this is a situation where the employee should have benefits or whatever. And you're looking at this and you're trying to be impartial, you're trying to be neutral, but you know that party self-determination means that a party should be empowered to make informed decisions, and you're saying that that just cannot happen. The result is going to be unfair. The power imbalance is so great. And what do you do? There's an old saying that a mouse whose tail is being stepped on by an elephant cares very little about your neutrality. Is there going to be fundamental fairness, and how does a mediator react under those circumstances? And as we get further into our course, again, we're going to deal with some of these dilemmas and tensions in more detail. But the point is that these fundamental norms are important, but they sometimes can conflict with each other, at least have some significant tension in how they are applied. But the idea behind them is this: party self-determination. Now, those that are directive mediators and those that are facilitated will give you arguments about why their orientation still upholds these three fundamental norms. Ultimately, as a mediator, you'll have to make a decision, if you're in that role, as to what your values are and what orientation you will adopt. Now, when we look at this, I think it's important to look at the author's view on the mediator's role, because I think they make some good points. And I like it, and in fact, this is what my approach as well. They endorse a broad problem-solving approach wherever feasible. Okay, so you start out with the idea that your orientation is going to be problem-solving. You're going to look beyond positions. You're going to try to find interest-based solutions where you can. And the very definition of broad problem-solving approach invokes this idea that you're going to explore the party's true interest. You're going to treat psychological issues as potentially important. You're going to look at emotions. You're going to have that lens and that lever. You're going to seek mutual perspective taking, restoration of relationships. So that doesn't necessarily mean you're going to go all the way to a transformative orientation or approach. In fact, those that are of the school of the problem-solving, interest-based mediation orientation often scoff at the transformative view because they believe that what they do inherently involves what the transformative mediators want to accomplish in the first place. It's just that the transformative mediators believe that you can't do both, and the problem-solving mediators believe that you can. So that's why I think the authors, they don't emphasize nor endorse the transformative model. They believe that some of the goals associated with the transformative model are built into the broad problem-solving approach. But they also believe that flexibility is important, that it's important to look at what the participants want, what are their goals, and try to meet the needs of the parties rather than seek to just satisfy the values of the particular mediator's orientation. It takes much of the tension out of the process by reducing one of the major sources of hyper-competitive negotiation conduct, and that's the fixed pie or zero-sum view of the world. If we can get past that idea, if we can have a view more consistent with the example of the orange, we'll go much further in finding satisfactory resolutions to conflict that are more therapeutic to the disputants and to people that we work with. Again, the mediator's primary duty is attempting to serve the party's own goals. So the facilitative mode in avoiding legal evaluation is important. Again, the facilitative mode in avoiding legal evaluation. But here's the catch: unless and until it is needed to overcome barriers. And I believe that that's important. When parties really want to have their matter resolved, and you're trying to be facilitative, you're trying to help and empower people to solve their own problems. But sometimes there are these barriers. They may be psychological, they may be cognitive, there may be any of the number of barriers that we talked about before. On a continuum and as a last resort, mediators, I believe, that are effective will be flexible and will continue to perhaps be more evaluative on this continuum as the problem becomes more difficult to solve. So the most effective mediators, the authors say, are flexible. I agree. They're able to demonstrate behaviors associated with each of these different approaches depending on the context and circumstances of each dispute. And so, I would also agree, they endorse a context-driven model. For those that are pure facilitative mediators, they won't be mediating long if they go in and are selected to mediate an insurance company claim for personal injuries, and they go in and try to be transformative, or they go in and try to be facilitative and force parties into joint sessions they don't want to be in. That'll probably be the first and last mediation you handle with those parties. So you have to be sensitive to their goals, their desires, because after all, the dispute is theirs, not the mediators. And I believe it's wrong for a mediator to enforce or to impose their own values and orientation on other parties. Now, you can draw the line if parties want you to do something that you believe is unethical or inappropriate, then it would certainly be fine to withdraw as the mediator in that particular context. So what are the variables in determining the right goal and the role? First, look at the parties. What are the parties' goals? Like I said, if this is a personal injury litigation case and you've got an insurance company and a very experienced lawyer representing a party, and they tell you, we want to start out a caucus and we want to do it in this way or that way, then you're looking at their goals, not yours. Do the parties want a facilitative, evaluative, or transformative mediator? And many times they'll be upfront with you about that, or in your pre-mediation conferences, you'll find out what each party wants. And then, like I said before, if you're dealing with parties that have very significant unequal um, power in this mediation, both in terms of knowledge, experience, resources, you have to decide whether each party can negotiate effectively without the mediator's input, or whether or not the party is so incapable of participating in the mediation that even with mediator input, it would be unfair without the mediator stepping over this line and becoming more of an advocate. So again, are the parties sophisticated and or represented by counsel? You might have both parties that have very experienced, knowledgeable lawyers or representatives. And then again, how much hostility exists? I've been in mediations where I can hear the echoing of people screaming at each other before I even arrive 30 minutes before the mediation. And it becomes very apparent very quickly that this is a mediation that's not going to begin in a joint session. So again, the parties. The dispute, is this a single issue, or is it a divisible multiple issue problem? You know, is this a relational dispute or a one-time transaction? It's going to make a big difference if you're dealing with an employee that's been with a company for 35, 40 years and has an ongoing relationship versus someone that has had a job for 1 month and for one reason or another has some kind of a dispute. Also, whether or not it's a dispute between people that are related or had a close relationship or are close friends, and a dispute between total strangers that happen to be in an automobile accident. So again, you have to look at the complexity of the dispute. Single issue, divisible issue, how many parties are involved, and how many stakeholders, who's going to participate, how predictable is the outcome in court. You know, sometimes people take ridiculous positions in matters that the outcome is very obvious, even though, as I said before, there's no sure things. Some no sure things are closer to that than others. So all of these things become variables in determining the right approach as well. And then, of course, there are external factors. Again, time restraints. The court, we in our clinics here at USC often have students that mediate in small claims courts. And so we go to the court on a morning calendar, the parties show up for their trial, and the judge may say, you can go out in the hallway and mediate before you have your trial. Well, you don't have a lot of time, so parties go out in the hallway, but at some point in time, usually within an hour or so, the judge is going to say, okay, if you haven't settled it, come back in. So you don't, under those circumstances, often have a lot of time. There also might be a mediation culture, you know, about what's expected in this particular organization or in this particular community, in this particular profession or business or whatever. And so you have to look at those things, those external factors. Now, that concludes really this lecture today. Thank you for your attention, and I look forward to seeing you soon. Thank you.